this as that three-judge bench lifted the conservatory orders barring the swearing-in of Professor Kithure Kindiki as Deputy President of the Republic of Kenya. In that regard, we expect the swearing-in ceremony to be held tomorrow, where details point at KICC being the venue. But let's just go back to the crux of the matter. So much to talk about, so little time. I have to thank our panelists for being patient with us. We're still joined by Willis Otieno, advocate, Kathy Irungu, political analyst, and Dr. Duncan Ojwang, who's an advocate. And equally virtually, we expect the presence of Eric Komolo, who's an advocate and legal scholar. So before the break, we had just canvassed a couple of issues.
Exactly. And, Komolo talked about the issue of the jurisprudence that is being established. Willis, even as you add on to that, we've all through the month, all through this process, we've talked about the precedents that this process is going to set. From today's happenings, what precedents has it set when it comes to the impeachment of a deputy president, or maybe in another case, a president?
In fact, let's start by this. As a legal practitioner, I'm actually at a loss at what our courts nowadays say. I cannot advise a client with certainty when they present me with a set of facts and I look at the law. I cannot tell them with certainty this is what the courts will say. Because look at the trends. The case of the lady in Meru, the governor in Meru. Look at Wambora. Look at all these governors who, even by Guru, who've been impeached. When they go to court, there's a process. You're given a due process. The substratum of the case is preserved. There's a conservatory order. You deal with the main petition and dismiss or allow. That is what, as a legal practitioner, I've been trained that law is about precedent. That is the precedent on the questions of impeachment, that you preserve. Then after you preserve, you go now to the merits of the case and you allow or dismiss the petition. Then when you tell somebody you dismissed it, it's very clear. But here, two courts issue conservatory orders. Then an application is made to set aside. Now those two judges who issued the conservatory orders, they were on their own satisfied that there was a prima facie case and there was a need to preserve the substratum of this case. Then surprisingly, because as we know it as lawyers, legal practitioners, in such a case, normally what happens is they're given ex parte so that people can go to inter partes hearing of the application to confirm the orders. In this particular instance, priority is given to an application to set aside the ex parte orders before looking at whether orders should be preserved and the substratum of the case to be preserved, to be heard, then we make a ruling. I don't know. If you ask me to advise a client today that this is what the law is on the question of conservatory orders, I'll tell my clients, study the politics of the day. Because the judiciary will rule based on the politics of the day. That's what is coming out, in my view. But what are we doing to our legal system? What message are we sending to the people? We were previously in this position in 2007. Because in 2007, after the hurried swearing in of President Kibaki, the refrain was that if you have a problem, go to court. But the courts had taken a position before the elections. People had seen their contacts. In fact, the then Chief Justice Judiciary was sitting at 2 p.m. fully dressed with the gown and the wig and the robe, everything. Even before the elections are concluded, he was in State House sitting, waiting for the swearing in of President Kibaki as president. How did you know that he was going to be announced as the president? So that you will go there at 2 p.m. to do the swearing in. Now, when people are being told to go to courts, they knew how the courts were behaving. They decided, it seems, political disputes need not be taken to court. And Kenyans grabbed machetes against each other. And that is not a situation that we will wish this country to go back to. And that is why we came up. In fact, the constitutional moment for us was the experience of 2007. And 2007, if you asked me, the primary player that led us to 2007 was not even the IBC. It was the failure in the court system, the loss of confidence that the Kenyan people had in the court system. Because if we knew that the courts are there to genuinely litigate and to arbitrate over our disputes, nobody would have had a problem taking the dispute to court. But people knew going to court was kichinjio. So we can as well change each other. on the streets. Why must we take it to court? So I am seeing a clawback to our constitution. The judiciary, either subconsciously or consciously, is clawing back to our constitutional gains, and a pattern is emerging where the court seems to be making decisions that in the minds of the people are decisions which only favor William Ruto's administration. And this is dangerous. The perception of it, there may not be truth in it, but the perception of what is the common man is seeing on the street is that whatever William Ruto wants, William Ruto gets. You saw yesterday the Supreme Court judgment that came out. I mean, it's nonsense. When you see a court telling you that you can have a budget without revenue estimates and without expenditure estimates, and Supreme Court telling you that public participation, as long as you've appeared in a particular forum, you've shared your views.
Okay.
They don't need to, the policymaker doesn't need to give you the reasons why it's rejecting your views. An act that was rejected by 90%, over 90% of Kenyans rejected it. No reasons given why their views were rejected, not taken into account. So people say, that's okay. So I am seeing an ominous sign, and I'm a reader of signs. I'm like the prophet Elijah. I can read signs. And the signs that are coming out of that Supreme Court are ominous signs. The Supreme Court is sending a feeling down to the people that a perception is now developing that William Ruto has already captured the courts. And if that perception is not going to be eradicated, then there's a very huge danger coming ahead.
Okay.
We are going to have a problem in this country in a short while.
Okay, Kathy, I'm interested in your take from outside looking in. What happens when the perception is out there that the judiciary is perhaps leaning towards the executive? What happens to the sovereign? You know, what happens to the court's legitimacy as a neutral arbiter from where you sit?
I think from where I see it, the first challenge or the first problem that we got ourselves into is when the former deputy president actually got out there and gave a lot of information, perhaps actually unnecessary, because initially there's a lot that people didn't know about this case. And he came out and took everything to the court of public opinion. And he was sort of just telling the people, this is what is happening to me. I'm under siege, you know, those kind of things. And to a very large extent, he was also whipping the emotions of the people. So even before these things moved to the judiciary, I think there's a lot of damage that had already been done. And he had already set a stage of almost convincing Wanjiku that he does not expect any fairness to come from the judiciary. And if you looked at his lawyers, though competent, there was a lot of attack on the judges. And they came out, you know, gun brazen, and it was very clear that, you know, from what I read, it's like they didn't expect any, they didn't expect justice, which is really not true, you know, from where I sit. Having said that, I think this case, the way it has been settled right now, it has actually left our country a bit divided. And now we need to focus on, you know, bringing the people together. We need to focus on healing, even for the former deputy president himself, because every time he came out, I think I saw him come out, you know, several times and talking in a very emotive manner. I think we actually need to bring this country together, and we need to start working. No. We need to forget about all these, the political, the legal. I mean, the legal will continue, you know, because even the judges today called for that. But we need to start working now for the people of Kenya. Okay,
Dr. Ojwang, as you come in, there are those who have the school of thought that perhaps Professor Kithure Kindiki does not qualify due to process issues. That, number one, he was not a member of UDA at the time of his appointment as a DP nominee. He hadn't resigned as a public servant when he was appointed and his name forwarded by the president, that there's a lack of credible IEBC. We are commissionerless at IEBC. So how come he was cleared that fast? So there's some of the questions that are coming up. Well, what do you make of that issue around Professor Kithure Kindiki and the efficiency around his clearance?
Right. Of course, back to the temples of justice. And, court felt that there is hypocrisy. That there are litigants who you praise court when it gives you the orders. You castigate them when the same orders are lifted. And that appeared as hypocritical in the sense that you go to a court ex parte without the other people, and you convince court, probably not even having a physical court, just by what you have filed, and they give you a timeless order. And when a three-judge bench, notice all those are done by a single judge bench, and this was the 22nd attempt. This is after 22nd application. So you can also talk of the 20th other time it failed, and it succeeded twice in the court of a very competent judge, Justice Kerugoya Mwongo, and the other judge in Nairobi. Then there is a three-judge bench. Compare 1 and 3.
No.
Constituted.
Let me be clear here.
I also said
when the High Court
prevent me
sits,
from talking.
when the High Court sits,
Yeah.
it is the High Court of Kenya, whether it is one judge or it is three judges. It's the High Court of Kenya.
Is it factual that there were three judges here?
But it is the High Court of Kenya. The order is an order of the High Court of Kenya.
True,
whether they were one or two.
True, Akili. But remember that empaneling motion was moved, that because this issue was so weighty, we need three judges. And if one head is good, surely three heads are even better. So that was the basis of empaneling a three-judge bench that sat through painfully, looking at sharp practices, looking at things meant to veto. The first application was whether they are even fit to sit. They sat through it, ruled whether they are fit to whether they should recuse themselves, whether the Chief Justice Deputy should have appointed them. So when you look at the journey, surely you cannot help but see hypocrisy in terms of we praise court when it moves in our favor, and we castigate them when it doesn't. But beyond that, look at it this way. This is not the only impeachment. There will be other subsequent impeachment. It is in the Constitution. People will still misbehave. People will still talk of other regions as less, and people will violate their oaths. So it is important, even if Professor Kindiki is sworn in, for this case to go through full hearing, so that we make the jurisprudence that Willis Otieno is concerned about. Unless the people who went to court felt it was frivolous and it was only for the sake of stopping the swearing in, otherwise it has no value. Because now the court can zoom in, without emotions, without personal interest, look at the issue. Now, for example, the question that I was asked about the role of IBC. Remember, court said, at this time we are dealing with preliminary objections. And that issue of whether IBC has a role is one of the main issues that will be decided. But beyond that, of course, arguments have been advanced that is tortured reading of the Constitution, because the Constitution comes with two tracks. One through impeachment that has no route through IBC, that simply goes and says in black and white in the Constitution, Parliament vote, the President nominate, Parliament vote, you are Deputy President. So those are issues that will be castigated. But as I conclude, I look at it this way. We have a Constitution in Article 159, which was not happy with technicalities. Lawyers want to hold things and win on technicalities. Article 159 is saying justice shall be done without undue regard to technicalities. So you have in one time somebody who, when they reach the penalty slot, they fall so that you are given awarded penalty. Thank God that judges are also lawyers, and they could see at this fault game and say, no, you have tripped yourself. Nobody, that was not a foul play, play on. Now they're saying, you had a case, we have agreed. If they said in prima facie case, we can see you have a good case. Now come, let us do it in court. Why run as if the world is ending Yet the court balanced the public interest, national interest, vis-a-vis an individual interest in holding an office. There is no right to holding a public office. Public office is trust. Public office is not a personal property. It is based on trust. There is no right. He's not being sent to jail. He's not losing his liberty. He has simply lost the office. Finally, the Constitution says this Constitution is meant for the welfare of family, individual, the society, and the nation. In the preamble. So it cannot just lean about individual. And the court said we must balance. Here is an individual who fell sick on the process, unfortunately, moved away from the process, was in current hospital. Those are substantive issues. But here is the nation. Here is the government that must have its offices occupied. And in the balance of scale, they said, for now, you are not going to enjoy and be a porter without carrying luggage, enjoying the order from Kerugoya. We are going to suspend it. We have ways we can even declare that things are reversed. Let us go to court and make jurisprudence.
All right, we want to get to Komolo, but before we do, Willis, you want to respond?
Let me say this. First, to begin with, it is very preposterous for Daktari to say that Ruto only nominates at parliament votes and that IBC has no role in the vetting. I mean, then what stopped William Ruto from nominating Salva Kiir to be the deputy president? He could have nominated anybody. He can't nominate Salva Kiir because Salva Kiir does not meet the qualifications of a deputy president. And those qualifications are found in Article 137, which sets out you must be a citizen of Kenya. You must be a registered voter. You must not have been a public officer for at least 6 months. They are found in the Constitution. So when William Ruto is doing a nomination and he's saying that Kindiki qualifies, he must look at 137.
Which he did.
You cannot look at 149 and ignore 137. If you apply 137, Kindiki does not qualify. He is an illegitimate deputy president nominee. And he will remain with that skunk for the entire period he will be in that office. He will be illegitimate. The process through which he has come in is illegitimate. Then IBC's role. You cannot say there's an election taking place that IBC has no role in it when it comes to qualification of a candidate. Because once Ruto nominates, or a political party nominates for other elections, it goes to IBC to ascertain that the person has actually met the threshold, the minimum qualifications. Then the name is subjected to the electoral college. In this particular instance, the National Assembly becomes an electoral college to vote on behalf of the people. That electoral college is going to deal with someone who meets the qualifications of 137 as ascertained by the electoral management body, that is IEBC. So you cannot say that IEBC has no role, that their role is purely superfluous. Otherwise, you are telling me that Ruto can nominate Salva Kiir and Parliament will blindly vote for Salva Kiir to become a deputy president here in Kenya. It is not possible. Okay. And that is what I say. With Kenya Kwanza, anything is possible. I cannot advise anybody on the law in this country anymore. I will tell them what the law is, but I'll tell them, read the political mood of Kenya Kwanza and William Ruto. Okay. Because it seems everybody, even doctors, are now dancing to the tune of William Ruto and ignoring what is the plain letter of the law as we all know it.
Okay.
He'll have a chance to defend himself.
Yes, definitely he will. But I want to bring in Komolo. I mean, last week we had this conversation and you said that, pardon me, Professor Kithure Kindiki would not want to assume office in a shrouded manner. If you've been following this conversation, the issue of perception has been raised. And, looking at it from a Kenyan point of view, this particular issue has divided the country more than united it. Just weigh in on that.
So actually, it's true that they say that Professor Kindiki, and I still believe that, will not want to assume office in a rather shrouded way. The truth is that the ruling today has cleared its path to the extent that we don't have a conservatory order. Another truth is that I'm not sure whether his lawyers have filed any notice to the Court of Appeal, which may then lead to having a conservatory order in the morning. Another fact is that there is already a process to swear in tomorrow from give or take 10 a.m. But at the end of the day, I do not want to participate in the politics of either side for the simple reason that I think that if we look at judicial decisions with a political lens, then there's a very good chance that we will lose the last line of hope. What I know for sure is that the general trend is that when conservatory orders have been issued by the High Court to preserve the substratum of the issue in the petition, in this case, the process of removal of a deputy president, then generally those conservative orders or conservatory orders have been retained until the substantive dispute is determined. I mean, the best example you can have for now is the case that is happening in Meru, where there's a conservatory order. That is why Kawira Mwangaza is in office today, but having been impeached by the Senate. So it was, to my mind, a bit weird that the conservatory orders were lifted. In fact, I think it was, to me, a bit odd that the court decided to have a full day, really, to listen to just conservatory orders instead of bringing the parties to compromise. In my opinion, the entire day Tuesday should have been spent on hearing the petition and then deciding on the merits, because conservatory orders are substratum, really. So in essence, if Professor Kindiki is sworn in tomorrow, then essentially the litigation that Gachagua is trying to seek in terms of remaining deputy president is defeated. But I also listened carefully to the ruling. I listened to what the judges were not saying. And I think what is happening is that perhaps this issue of impeachment should not be a judicial process. They went to great lengths giving us authority from the United States, where the U.S. Senate has final say in final and exclusive say in the impeachment of, in that case, also a judge, but many other impeachment processes in the U.S. Here in Kenya, we have a mongrel. So Article 144, for example, stipulates when a president, and for that matter, deputy president, is being impeached on the question of mental infirmity, that is mean medical situation, then the decision of the Senate is final. In other words, courts don't have jurisdiction. Now, when it comes to impeachment, removal from office through impeachment, that's Article 145. Article 144 is removal from office by dint of mental infirmity. So when it comes to 145, courts have jurisdiction, because it doesn't say in finality that courts do not have a say. So that's the conundrum we have found ourselves. And I think that perhaps to save the courts, this entire politicized dispute that then makes judges perceived to be influenced, then perhaps for the first time I recommend that we need to rethink the Constitution in terms of impeachment so that we remove political disputes from judicial process. Because the truth is that the judges contradicted themselves. They identified three issues. One is whether they have jurisdiction. They said yes. Two is whether the issues raised by the petitioners, including Mr. Gachagua, are justiciable. In other words, there are issues that should be looked at by the court to see whether there could be constitutional infractions or not. They said yes. Then the third one is whether to lift conservatory orders, and that's discretionary. It depends on how you interpret it. The approach they took is that the Constitution does not anticipate vacancy in the office of the deputy president, which is right. The other approach is they could have taken exactly the opposite approach, which is also right. That when there's a conservatory order, then the holder of the office remains in office. If they took that approach, we'll be arguing a different thing here. So either of the position is fine. The problem is it is highly politicized because, as you can see,
Okay, Komolo, and I understand we can't draw parallels exactly with the US because, according to my limited knowledge, the Chief Justice in the US sits at the Senate when it comes to some of this impeachment proceedings. But I'm tempted to draw you back to what Anthony Mrima had to say and just briefly give me your take on it, because the High Court judge mentioned this. I'll quote him verbatim. We find that the constitutional framework does not envision any scenario in which the office of the Deputy President would remain vacant except during the brief period required to fill a vacancy. Earlier on, we had from Willis mentioning that, the 60 plus 14 days gives us approximately 74 days in terms of this changeover. Why the hurry? And we had from the justices mentioning that it's public interest that demands that the DP's office should not remain vacant. So is it 74 days or should it be filled as fast as possible? Hence why they lifted the conservatory orders. Briefly.
The fact is that the Constitution anticipates a procedure that goes up to around 74 days. That's the fact. But then it stops there. It doesn't give procedure that the National Assembly has to go through. It doesn't give the procedure that the president has to go through to nominate somebody, which is why these are the disputes around whether Professor Kindiki is a member of UDA and a registered voter, and all these other things are largely secondary, but they are important because they are in our election laws. The fact is, the entirety of 2010 Constitution was designed to bring about some level of predictability, but it didn't try to cure our political behavior. What is really happening is our political behavior. Political behavior simply means that we do have interests that are not necessarily captured within the Constitution, but they define how we govern ourselves. So, in essence, in an orderly system, we would have expected that there's litigation. After litigation, then Professor Kindiki assumes office. Through that process, that then would have invited views, say, from the public on his suitability or otherwise, and many other things that are now arising, and that, by the way, are not going away. They are going to be part of the litigation even after he assumes office. So, in essence, I think there's a lacuna in our Constitution to the extent that it brings impeachment processes, which are inherently political processes, into halfway into a judicial system. At a particular point, it says they are not, which is why Article 144 is there. Then at another point, it says they are, which is why Article 45 is there and we are there. So I think that it is almost impossible, except for people who have taken stand, people who, obviously because of political background, will be biased. And it is obvious that there's a lacuna. And that lacuna has to be cured through perhaps a review to cure it. But all said and done, I think that it is obvious to us that Professor Kindiki is now the president-elect. He will assume office. And what remains for Mr. Gachagua, in my opinion, is continually getting an absolute hold of his position as a non-impeached former deputy president, because impeachment has serious consequences, including going for his political future.
All right, thank you, Komolo, for that. Now, coming to you, Kathy, I mean, earlier on you mentioned that it is high time we work. But let's take a look at some of the issues that are being raised, for example, by Willis on the issue of trust towards the judiciary in such a case. Let's not forget that the legislature, that is the arm of the government, has been, many people keep on saying that it's an appendage to the executive. So if in this case we have a legislature that does the bid of the executive and a judiciary that cannot be fully trusted, where are we going as a country?
I think even of more interest is the fact that some people say that we really don't have an opposition, because the people who are in the opposition are now in government. But I still believe that we have part of the opposition that was actually left out there, and that is why we can see them, actively participating in doing oversight and all these other things. But then I hear what you're asking, and from where I sit, I do not think that the judiciary acted abnormally, because if you look at the separation of power, this is what the National Assembly and the Senate were supposed to do. And then, of course, when the petitioner moved to court, then this is what the judiciary was supposed to do. From where I sit, as I said from the beginning, I did not find any anomalies, and I'm okay with the way the judgment went. And from here, the former deputy president, just like any other person, he's free to seek further legal redress, and I think that is what we are going to see him continue to do. But then it is very important that we put this matter to rest as Kenyans, so that we can focus on more important issues. Because today, if you listened to the Kenyans, and I was here as you read the news bulletin and as you looked into all these matters, Kenyans are concerned about very many issues, including healthcare, education. Right now, this issue has shrouded everything else, and it's like we do not even realize that our young people are doing their KCSE and all these exams and keeps all happening. So I think it is time we put this matter to rest, so that we can also focus on all these other issues. But of importance is actually to look at our political behavior as Kenyans. I think we are very interesting lot. We get very excited when political issues are being discussed, which is very normal for us as a country. But then let's remember that we have very many other things that we need to look into. And it is important that we also wish, the incoming Deputy President, His Excellency Professor Kithure Kindiki, all the best in his new role as a leader. And let's also remember that we now need a Deputy President who is capable of uniting this country, and a person who is going to look at all of us as Kenyans, and a person who is going to be a symbol of national unity.
I want to just take you back to June, July this year during the finance bill protest. I mean, looking at the issues that were raised by the young, from corruption, tribalism, unemployment, and so on. A number of issues were raised up. And we got a new cabinet reshuffle, a broad-based government. And just then, when we were hoping that service delivery is going to be key, then what? Impeachment. So how sure, from a Kenyan who is watching us right now, how sure are we that this is just going to happen? Like, it's going to be a cycle that goes on, and yet the issues that we actually want tackled are not handled.
I believe moving forward, we are not going to see more, much politics being played. I expect there is going to be delivery of services to the Kenyans that elected this government, and even those who did not elect this government, because we are one country. And yes, it is true, there was agitation, especially from our Gen Zs and from the young generation, and from all of us. And people are actually calling, the executive and even the members of parliament to order and saying it's time, you start working for us as Kenyans, and we expect them to do exactly that moving forward.
Okay.
Dr. Ari, as you defend yourself on the issues that were raised a little bit earlier, I'm curious, and perhaps Kenyans are equally curious on this issue, that of course the embattled Rigathi Gachagua still has chance of legal recourse, legal redress and whatnot, but yes, legal redress to what point? We heard that it's almost impossible for the courts to remove Kindiki once they find that, Gachagua had a substantial case and he poked holes into the process around the impeachment. What's the compensation that Gachagua can get from the courts at this particular point, bearing in mind continuation in government seems to be of utmost priority?
There's still a lot that he can get, and I think once we stop looking at impeachment as a self-interest issue, as we are doing, then we can really get into the law of impeachment and what it is meant for institutions in terms of accountability and in terms of parliament oversight. But as long as we are locked in and maybe using politicized sound bites, maybe using social media memes as arguments, then you hear things like, this thing will be tried in court until March 2027. That was what was being claimed. And there is the abuse of court processes that the court could see through. That you shoot something in court and hope to stall a legally constitutional process given to an arm of government like parliament and enjoy that period knowing you have a weak case. And we have seen this before. We had this with our election, where somebody even steal elections and enjoy the office saying, by the time this thing is decided, my term is over. And so the constitution is really clawing back on those kind of mischief and sharp practices. So what the court was saying, for example, is we knew that President Moi took 9 months without a deputy president. The constitution set to address that. And that is why it even envisioned a situation where if one is removed, this is what happens. So that we are not back in a position where the president enjoys all these powers and without an advisor. And that is why the court now weighed in terms of public interest and said that was weighing in. Now consider it this way. If the maximum days, and it is the maximum days, is 74, then that section of the law that is saying somebody must be a party member for 90 days mean they can never be a candidate for deputy president. That's how ridiculous that reading is. If it is 74 days maximum to finish this issue of impeachment, then if you say that that person must have been a party member by 3 months, it means that somebody who is serving as a public official can never be nominated for deputy president. I mean, that is absurdity on its face. And that is why you can see that we will gently guide them in court. And I hope people don't run away, because they need this gentle guiding and tutelage so that they understand that there is 2 regimes that are both speaking on how one can get to a deputy president. One through the election and another one through C-section, which is through the impeachment. But be as it may, I think that when you look at, and I agree with fellow panelists and friends, that this issue sometimes become emotionally potent. And when something is emotionally potent, there is a danger of oversimplification. It is good that now it is not a race towards saving an individual. Then now the court can sit without the gut you and all those legal technicalities and the sharp practices where every court here have been moved to stop the process almost. If there's 20 applications, then they can get to the substantial issues. And to me, as a student of constitutional law, I know that this impeachment is not the last, but is the first. It is important to have the court now sit and look at our jurisprudence and look at what was meant for impeachment. And the court gave a hint that, you know what, it's not our intention. I was even shocked. They said they kind of leaned towards the US jurisprudence, that it's not our intention, though we have jurisdiction, to veto another arm of government. Now, this impeachment, the framers, in their wisdom, put it in the hands of elected leaders, parliamentarians. And as Omolo was saying, the court affirmed the constitutional text that is saying, upon voting 2/3, then the deputy president shall stand impeached, and there is no unwinding. Why? The constitution has already given a lot of measure. You need a supermajority. You need a third to sign that impeachment motion. You need 2/3 to impeach in National Assembly. You need 2/3 to impeach in Senate. I mean, if I was being fired from my job at the university, will I get that due process? How much process can somebody get that we still talk of their right to be heard?
Okay.
Well, laws of natural justice. I know you'll come in on that, but equally, did this review of conservatory orders prejudice Gachagua's rights? Because we heard from the three-judge bench that no individual can suffer damage if the Constitution is implemented as is. Your take on that?
You know, the first thing, and where I really shudder, is this question, what is public interest? From the time I started reading law, public interest, we always understood it to mean to obey the Constitution. There is no greater public interest than to obey the Constitution, to just apply the provisions of the Constitution. There can never be any greater public interest. So that if what is before the court is a question of violations of the Constitution, the public interest should be to make sure that we protect the Constitution, we apply it. You can't tell me that it's in the greater public interest, national interest, to give Ruto his deputy as he so desires, or to ignore Gachagua's fundamental rights. And it is important to note, of the absolute rights, the one that can never be taken away, as provided in Article 25, is the right to a fair hearing. It is an absolute right. It can never go anywhere. It's as good as even if you can never go. That is what Gachagua was presenting before the court in regard to how the Senate handled him. So they decided to ignore him. And I'm saying this, sometimes people think that I support Gachagua. I don't support Gachagua, but I support his right to the due process of the law. Even if I disagree with him on his politics, but he's still a citizen who is entitled to the protection of the law as set out in the Constitution.
Okay.
Daktari here was a cheerleader of Gachagua when he was deputy president, before the impeachment process started. I was attacking Gachagua. Today, I am the one amplifying the need to protect the rights of Gachagua as an individual. And yet the one who was cheering him on, when he was talking about the things he was talking about, is the one saying how he must go, because political experience for today desires that he goes away. What I don't agree with is this approach that seems to be percolating in this country now, especially within the political class, like Kenya Kwanza and some in ODM, and now the judiciary, that what is politically expedient today, let's do it. We don't care about the president we are setting. We don't care about institutions. And I'm simply saying, if it comes to you want to remove Gachagua politically, it may be political garbage to you. Do it in the way that the Constitution requires and respect his rights while doing so. And there's one thing as I conclude that I want to say. I said it in the Supreme Court in 2022, and I repeat it today. There's what we call regime legitimacy. One thing that a judicial process does in a political contest is to give a regime what is referred to as regime legitimacy. So that by the time that regime goes out to serve, the people feel that it was a product of the due process of the law, that their voices were respected, that their laws were followed. Kindiki is going to start serving without legitimacy. He will be an illegitimate deputy president. He'll actually be seen as a stooge of William Ruto. The people who he is meant to serve will not give him the confidence, will not give him the public goodwill, the good energy that you need to serve them. And the courts are cheering him on. William Ruto lacked regime legitimacy from the time of 2022 petition, because the issues which were raised, remember when you're litigating a case, you have two audiences. You have the judges and the public. Kenyans are now woke. Kenyans are enlightened. They have access to the Constitution. They can read. They can form their own opinion. They can access the facts. And they can see when the law is not being followed. So you may win in the courts of the judiciary, but you will lose in the courts of the public opinion. But when it comes to service, you are not going to serve in the courts of the judiciary. You are going to serve in the courts of public opinion. And that is why regime legitimacy is an important ingredient to any regime. William Ruto lacks it, Kindiki is going to lack it, just because of the manner and the process in which we are leading to him being sworn in.
Okay, Komolo, coming to you, even as you respond to the issue of legitimacy, there are those who are saying that, you know, this is a chance for the president, that is William Ruto, to push the reset button for us to move forward as a country. From where you sit, how best can he push that reset button?
Well, I think the president has good enough political advisors to advise him on how to push political button going forward. I think the political elements of this are beyond me, but it looks to me like the differences between him and his deputy were largely political, and certainly the deputy president did manage them well. And I'm not sure of what led to impeachment because it came a bit fast. But we are where we are. It has happened. And the court has decided it's justiciable. So the deputy has opportunity to ventilate his concerns. My worry, and I need to emphasize this, my bigger worry is the perception that the judiciary may be in bed with the executive. And I can understand those who take that position primarily based on the history of how to handle conservatory orders. As I said earlier, if I were in that bench and I wasn't, then I think a more progressive way would have been to encourage the parties to compromise the conservatory orders for about a week or two, and so that the entire period we have spent talking about conservatory orders, we should have moved to the main petition. And listening to their ruling, which took just about an hour, what I saw is that they were actually also talking to things that should have been handled in the main petition. And so it's unusual, very, very unusual, that I need to say across the Commonwealth that conservatory orders are lifted in the circumstances they did. And that is the main reason why I finally concluded that perhaps impeachment processes should not be judicial. We should not have a mongrel of one being judicial and another. Having said that, I've never thought that we have a constitutional crisis in Kenya. I think it's a political crisis. And to be more specific, I think it's the disagreement amongst elite. In this case, it's manifesting that's a disagreement between the president and his deputy. Details we don't know, but it's also not unusual that even the political opposition calls for mandamus and things like that based on what, if you look deeply, is elite disagreement. So we do not have a constitutional crisis. We actually have a working constitution which gives everyone some kind of rights, including the Mr. Gachagua, rights in terms of where we are, where we were, and where he is headed. Yeah, I suspect they've even filed appeal to the Court of Appeal to stop the swearing in of Professor Kindiki and all that. So the Constitution is working. And so we should not rush to portion blame on the Constitution. We should be focused on how do we make our leaders, who happen to be political leaders, resolve their differences in a manner that does not create unnecessary national attention. I mean, by national attention, I mean we've spent about 2-3 weeks here focusing on impeachment. During this same period, you and I are reading the media that there are several people who are not accessing healthcare the way they want. There are students who have done irregular CAPSEA exams, who are not registered, have done exams for last year. That's a serious fraud. We are reading a lot of other things that concern you and I as ordinary taxpayers in Kenya. So in other words, the government, or at least the public attention, is not focused on something more basic, and which is where governments are there, to serve us, not to superintend or watch or comment on elite wars. Because I genuinely don't think that the disagreement between Mr. Gachagua and Mr. Ruto are so fundamental that they could not be solved at a political level if conditions
all right,
having said that,
well noted. Due to interest of time, allow me to cut you short on that particular point, but you've definitely expounded on that issue. Thank you so much for your input right there. And perhaps as we get the final remarks from our guest right here in studio, I'd like to start with you, Kathy, because this falls under your foray, your expertise when it comes to political analysis. What exactly happens? What's the blowback of this move to impeach the deputy president. I remember him mentioning a little bit earlier on that the mountain forgives but does not forget. So is there any political blowback that will play out, especially in the Mount Kenya region, or the faster Kithure Kindiki is sworn in, the faster the mountain moves on from, the truthful men?
Okay. Right, let me start by saying that I'll put it in Kiswahili because the former deputy president used to tell us msiguze mlima. And to me hakuna mlima umeguzwa. Yes. The reason why I say this is because moving forward, we are likely to see a lot of alignments and realignments, and that is purely political, and that's how this country has been run, even, for the last many years. And when you go back to the Mount Kenya region, if you look at what is happening there, I know I think twice, the former deputy president has called the people to be peaceful. He's called the people to maintain peace and ensure there's no violence. I mean, there can never be violence in Mount Kenya region. Our people are actually known for that. People will not stop going to Marigiti to sell their potatoes so that they can go and protect personal interests. At the end of the day, and after all, when you look at this issue very clearly, to me, the former deputy president was actually using the Mlima. He was actually using the Mount Kenya people to create a buffer or even to protect himself, so to speak. And for that reason, I don't expect to see any challenges, and I would actually extend an invitation to the president of Kenya to go back to Mount Kenya region, pay them a visit. Okay. I remember before 2022, he visited Mount Kenya region, I think almost every Sunday for Harambes and things like those. I really want to extend an invitation to him to go back there and visit the people once.
So the ground hasn't shifted.
The ground hasn't.
Interesting. As we get Willis's final remarks, Willis, Professor Kithure Kindiki has a full entry in terms of the expectations of that office. Agricultural reforms, dairy, milk, coffee sector reforms. He'll be chairing IBEC, which is quite important in terms of coordination with these devolved units, re-establishing development partners coordination and strengthening cooperation with Kenya's partners. What do you expect of him, bearing in mind he was criticized of his role as interior minister?
Yeah. When you want to judge a leopard, you look at his spots. And a leopard doesn't live in spots. Kindiki's tenure as CS Interior is marked by the deaths of over 60 Gen Z who were killed by police, and not a single officer is in court today to answer. Kindiki's tenure as CS Interior is marked by forced abductions and disappearances of so many Kenyans. Bob Njagi, Joshua Okayo, the Lincoln brothers, Aoko now is missing. That is Kindiki for you. Now, if you think that he's now moving in, that things will change, I mean, he's just joined two birds of a feather. William Ruto had previously been charged with ICC, crimes against humanity. Kindiki was doing exactly the same thing as the CS Interior. He's now joined him. They are two birds of the same feather. They have joined together. So that is good. Fair enough. They can continue. But to say about the invitation to William Ruto to go to Mount Kenya, I will just add that when Ruto goes to Mount Kenya, let him ask them to play for him this song by Kamaru as a welcoming song. It is a very emotive. Let me just finish. It's a very emotive song.
Yes.
And I will wish that William Ruto plays that song by Kamaru, that it talks about the unity of the people and the fights of the people, and for those who are selling this country, the land of the nation, to foreigners, just like he's selling it to Adani. Let him go to Mount Kenya and play it, and I assure you, you will receive the most rapturous welcome in the region. As I conclude, for me,
yes,
all this will not change. The issue of when Kindiki is going to chair IBEC, that IBEC is going to find that counties have not received their disbursements now 3 months. There is no money. Our odious debt, they are still taking illegal debts today as we speak. The cost of living is still a problem here. Kenyans are still dying in shift and share nonsense that they've come up with. They are not even able to transit. They can't even come up with the redundancy period, how to move from NHIF to shift share. That is not going to happen. The kidney dialysis patients, the cancer patients that I see, who are not able to access healthcare services, they are still going to suffer, because the problems with Kenya Kwanza, what the pain you felt today is more than the pain you felt yesterday. And the pain you are going to feel tomorrow is more than the pain you are feeling today. That, to me, is the summary of Kenya Kwanza. And the appointment of Kithure Kindiki, if it was welcomed by the people of Kenya, you will feel the national mood. You will feel the energy of the people. As it is, no one cares.
Okay.
And the writing was on the wall for Kenya Kwanza on the 25th of June.
All right.
Mene, tekere. This regime's time is over.
Interesting. Daktari, we have to give you the final chance to give your comments, remarks as we conclude this discussion.
Thank you. And great conversation. I think the Constitution came to correct our political hygiene. And I'm glad that we are one of the countries in Africa that does very smooth transitions, thanks to this Constitution. The issue of perception, public, legitimacy, those are what I call witch logic, because it's not quantifiable. It's like saying so-and-so is a witch, you cannot prove it. But what I know is that this Constitution gave judiciary political hot potatoes. For example, impeachment is an hot issue. Where does Parliament get to know who qualify? Parliament vet people for positions every time, including CSS. And they look at the qualification. And the Constitution binds every actor. So it's everyone should look at the Constitution and look at who is qualified. Okay. Now, look at what has been happening as I conclude. Remember, they started with recuse yourself. You are not empaneled well. And then this is the third, actually. And therefore, you can see that thanks to the judge and the bulwark of their expertise, they could see that they cannot just play on technicality. So let the case move. Let us see the real issues that are being canvassed so that we perfect our impeachment jurisprudence. For some of us who teach constitutional law, we can't wait for those rulings. But court, the line between politics and the Constitution should not be divided too sharply. Impeachment came as a legal remedy, but yes, it is true, it's also a political process.
Yes.
And there's nothing wrong with that, because Constitution came to regulate, including relationship. So here is the hypocrisy. If these two people don't get along,
yes,
you want somebody to still stay in the office and the earned salary of a deputy president without work at the expense of Kenyans. If that's not hypocrisy, then I don't know what is hypocrisy. Thank you.
So I only have one clarification.
Very briefly, yes.
Yeah, actually in second. Our diversity is our strength. And I know, I've listened to my friend here, Wakili Willis, and there seems to be a notion that these Kikuyu songs that are being sung right now are like songs of war, or people are going into war or something like that. Every time we need to embrace each other.
Yes.
And those are songs of unity. They unify us as a people, and as Kikuyus, and as gamers.
As Kenyans.
And
they should sing it for Uhuru Kenyatta, for Ruto, when he goes to this.
Yes, we will.
All right. Well, that's a story for another day. Gentlemen and lady, thank you so much for your input. Was joined by Kathy Rungu, political analyst, Dr. Duncan Ojwang, advocate, Willis Otieno, advocate, and Eric Komolo, who joined us virtually. He is an advocate and legal scholar. We definitely appreciate your input. Let's take a look at what we'll be waking up to tomorrow, Ashley.
Of course, the headline in tomorrow's Standard is what awaits Kindiki. Bittersweet. Abraham Kithure Kindiki will this morning be sworn in, that is tomorrow morning, as deputy president to succeed embattled Rigathi Gachagua, whose fate was sealed in a judgment yesterday, lifting orders stopping the interior CS session.
Okay, that's one of the stories that will be canvassed extensively on tomorrow's edition of Kenya's bold newspaper, the bitter-sweet turn of events that played out today. Equally, another story touching on IMF wanting Kenya, or warning Kenya, as it releases 78 billion shillings. Not just that, another story touching on the irony of Kenya's low inflation but empty pockets. So much has been encompassed in tomorrow's edition of Kenya's bold newspaper. So make sure you grab yourself a copy. Find out what exactly awaits Kindiki as he assumes that position of Deputy President of the Republic of Kenya. And of course, Ashley, as KTN, will keep you updated on the proceedings that will play out tomorrow. Trust us to inform you.
Definitely. Well, that's how we wrap things up here on KTN Prime. Thank you so much for joining us and staying with us all through this. How many hours has it been?
It's been a couple of them.
Well, we appreciate you. As always, we don't take it for granted. I'm Ashley Mazuri.
And I'm Jesse Rogers. Good evening.
Good night.